The Muslim have constitutional right to manage its own affairs in the matter of religion because Waqf property belongs to Allah. They have also the right to administer such property. The purpose of the bill is a clear breach of the right of the Muslims to perform their religious duty, to manage their religious affairs, and therefore completely in violation of Article 26 of the Constitution of India. The bill hits basic structure of the Constitution. Madam, under Article 246, sub-Article 1, the Parliament has an exclusive power to legislate a law under 7th schedule of list 1, and under Article 246, sub-Article 3, the state is having the power, state legislature is having the power to legislate the law, exclusive power. Sir, excuse me, sir. Sorry. That is to say, land comes under list 2, under entry 18 of the state lists. Lands and buildings vested in or in the possession of the state comes under entry 35 of the list 2 of the state list. In the proposed Waqf bill, the Parliament has no power to legislate any law in respect of the land and building vested in possession of the state in respect of the Waqf property, because the state is only having power to legislate such law. Therefore, the Parliament is now encroaching upon the power of the state legislation in deciding the question of the land and building of the Waqf. Thus, it is completely unconstitutional and divorces the Article 246, sub-Article 3 of the Constitution of India. This is also hits the basic structure of the Constitution. By exercising any power under list 1 or list 3, state legislative power under list 2 cannot be encroached. There is a difference between a Waqf recognized by the Muslim law and religious endowment and recognized by Hindu law on the one hand and public charitable trust as contemplated by the English law on the other. The question has been considered by the Privy Council in Vidya Bharuti Tirtha versus Bulsami Ayar, long before. Mr. Amir Ali, who delivered the judgment of the board, observed that it is to be remembered that a trust in the sense in which the expression is used in English law, when the gift is directly to an idol or a temple, the season to complete the gift is necessarily effected by human agency. Called by whatever name, he is only the manager or custodian of the idol or the institution. In no case is the property conveyed to or vested in him. Similarly, that is a basic difference. The Honorable Minister, he was speaking about the Hindu trust. The Muslim law relating to trust differs fundamentally from the English law. Hindu trust follows the English law. Muslim law doesn't follow English law. That is a basic difference. Mr. Amir Ali said the Mohammedan law owes its origin to a rule laid down by the Prophet of Islam and means the tying up of a property in the ownership of God the Almighty and the devotion of the profits for the benefit of the human beings. As a result of the creation of a waqf, the rights of the waqif is extinguished and the ownership is transferred to the Almighty. It is religious. If it is religious, comes within the ambit and scope of Article 26 of the Constitution.